Affairs Council. Dr. Rubenstein, thanks very much for your time. For your reaction to reports around this morning that the compromise is being put to the coalition party room in about 15 minutes from now. My understanding is that it includes a removal of the words insult, offend and humiliate, but include intimidate and replace those other words I mentioned with the term harass or the offence harass. What do you make of that?
I think it's bad policy and it would be bad politics. I see no justification for making that change. We have 20 years of case law, which makes it perfectly clear the 4 words in 18C, offend, insult, humiliate, intimidate, are regarded as one very serious test and not a mere slight. Worked very well for 20 years, except for one controversial decision. And going into the pond of harassment is a totally different ball game. It probably undermines the ability to bring cases against racist speech, which communities now have. And we're into the area of criminal offence, which should be the responsibility of the state, probably under other legislation. So I don't see any sense whatsoever in terms of making that change. And on the other hand, of course, the process changes we've heard about make a lot more sense and deal directly with the real problems which have been exposed by this excellent parliamentary committee of inquiry.
Well, you referred to the case law, and I've spoken about the judicial precedents of rulings by, well, most notably Justice, Federal High Court Justice Supreme, Chief Justice Susan Kiefel, I should say, but basically a tougher interpretation of the law than the words might otherwise suggest. What about the argument that you should change the wording of the law to say what it means?
Well, look, the case law demonstrates what it means. And what is the argument and what is the evidence for changing the law to get us in a better place? I've seen very little. What is it you can't say under the current legislation that critics would like to say? I think one thing we can be thankful for is that those more extreme positions for throwing out 18C altogether have been put in the rubbish bin where they belong. So we are in the zone of finessing. But this sort of finessing, I think, is counterproductive, especially at a time when the government commendably has brought down a reaffirmation of Australian multiculturalism, a great success story, as the Prime Minister correctly put it. And of course, racism and discrimination go against the very fibre of Australian values. So diluting the law in the way that this sort of change would definitely do would undermine the credibility of the government at a time when it's reaffirming Australia's excellent track record as a very successful multicultural society.
The argument that you're removing subjectivity, though, from it, and making it more definitive in that sense. Is there anything to that argument in your view?
Well, nothing. It's not a subjective test. It's not a hurt feelings test. And it's not just offend and insult, as critics keep claiming quite fallaciously and misrepresenting the situation. The 4 words are taken as one test and one very serious test. Serious effects, not mere slights. So, you know, there's nothing to this notion of subjectivity. It's an objective test as applied by the courts. A reasonable person in the claimant group. How they would feel. Yeah.
Okay. Dr. Colin Rubenstein, appreciate your time this morning on late notice. Thanks for that on AM Agenda. That's all for our program.